Hello and welcome. Once again, thank you very much for joining me in this Katiba Reflections with Charles Nyachae. Today, I would like to reflect on Chapter 9 of the Constitution of Kenya 2010, which is the chapter on the executive. You will recall that in Chapter 1 of the Constitution, the people of Kenya declare that sovereignty belongs to them, and they further declare that they will exercise this sovereignty either themselves directly or they will delegate it. And previously, we looked at legislative authority of the people, which is delegated to Parliament. Of course, there is another aspect of legislative authority which is delegated to the county assemblies, which we will look at when we reflect on the chapter on the devolution, where the people delegate their authority is to the executive. Again, here we are talking in Chapter 9, we are talking about the national executive. The executive at the county level, we will look at when we reflect on the chapter on devolution. So let's begin with part 1 of Chapter 9, where the Constitution deals with the principles and structures of the national executive. At Article 129, the Constitution provides that executive authority derives from the people of Kenya and shall be exercised in accordance with this Constitution. So again, very importantly, as we saw with the previous chapter dealing on the legislature, even the executive who carry out authority on behalf of the people of Kenya can only do so, can only exercise it in accordance with the Constitution. 129 sub-article 2, executive authority shall be exercised in a manner compatible with the principle of service to the people of Kenya and for their well-being and benefit. Now, when we talk about the spirit of the Constitution, what 129.2 means, when 129 sub-article 2 means, is that those who exercise executive authority delegated by the people of Kenya to them must do so on the basis of the principle that they are serving the people, and they are doing so for the well-being and benefit of the people. Article 130 provides that the National Executive of the Republic comprises the President, the Deputy President, and the rest of the Cabinet. And we will see who are the rest of the Cabinet in a minute. Sub-article 2, again, here let's remember about the spirit of the Constitution, provides that the composition of the National Executive shall reflect the regional and ethnic diversity of the people of Kenya. That is a constitutional imperative. In practice, there may be arguments about how that is implemented, but it's important to reflect on the fact that it is an imperative that the National Executive should reflect the regional and ethnic diversity of the people of Kenya. Part 2 of Chapter 9 deals with the offices of President and Deputy President, who of course have been referred to in Article 130 sub-article 1. 131, the president, A, is the head of state and government. B, exercises the executive authority of the republic with the assistance of the deputy president and cabinet secretaries. So you will see from Article 131, sub Article 1B, that the executive authority exercised by the president in accordance with the Constitution is exercised with the assistance of the deputy president and of the cabinet secretaries. C, the president is the commander-in-chief of the Kenya Defense Forces. D, the president is the chairperson of the National Security Council. And E, again here we're talking about the spirit of the Constitution, the president is a symbol of national unity. Then 131 sub-article 2 imposes certain obligations on the person holding the office of president. It provides that the president shall A, respect, uphold, and safeguard this constitution. Of course, you will remember that this obligation is placed upon all persons by Article 3 of the Constitution, which we looked at previously. But the framers found it necessary because of the level of authority that is delegated to the executive as headed by the president, to state that the president shall respect, uphold, and safeguard this constitution. B, shall safeguard the sovereignty of the republic. C, shall promote and enhance the unity of the nation. D, shall promote respect for the diversity of the people and communities of Kenya. And E, shall ensure the protection of human rights and fundamental freedoms and the rule of law. So those are important obligations that Article 131, sub-article 2, places on the person who holds the office of president. The functions of the president, 132 provides that the president shall A, address the opening of each newly elected parliament. We saw previously that the president has an obligation to gazette the date that the parliament first sits after a general election. But now here, when there is the opening of a new parliament, the president has a constitutional obligation under Article 132(1)(a) to address the parliament. B, the president shall address a special sitting of parliament once every year and may address parliament at any other time. And then C, once every year, one, the president shall report in an address to the nation on all the measures taken and the progress achieved in the realization of the national values that are referred to in Article 10. This is an important constitutional provision because the president, as we have just seen, has that responsibility to respect, to uphold, and to safeguard this constitution. Article 10, which deals with national values and principles, is an important provision in the constitution, and the president is required to address the nation at least once a year on what measures the executive has taken and what progress they have achieved in realizing those national values. Secondly, the president is obliged to publish in the Gazette the details and measures and progress under subparagraph 1. So in addition to addressing the nation as regards the measures taken and progress achieved in the realization of Article 10, the president is further obliged to publish the details in the Gazette. President is, by virtue of this Article 132 sabbatical 1, C Roman 3, the president is required or obliged to submit a report to the National Assembly for debate by the National Assembly on the progress made in fulfilling the international obligations of the Republic. Sabbatical 2. The President shall nominate and with the approval of the National Assembly shall appoint and may dismiss the Cabinet Secretaries in accordance with Article 152, the Attorney General in accordance with Article 156, the Secretary to the Cabinet in accordance with Article 154, Principal Secretaries in accordance with Article 155, High Commissioners, Ambassadors, and Diplomatic and Consular Representatives, and in accordance with this Constitution, any other state or public officer whom this Constitution requires or empowers the President to appoint or dismiss. Sabbatical 3, the President shall A. chair cabinet meetings, B. direct and coordinate the functions of ministries and government departments, and C. by a decision published in the Gazette, the President shall assign responsibility for the implementation and administration of any act of Parliament to a Cabinet Secretary to the extent not inconsistent with any act of Parliament. This is what the President routinely does by way of issuing executive orders. That's where the constitutional power is derived from. Sabbatical 4. The President may perform any other executive function provided for in this Constitution or in national legislation, and, except as otherwise provided for in this Constitution, may establish an office in the public service in accordance with the recommendation of the Public Service Commission. Now, let me make a reflection there as regards that particular power that is given to the President in context and in give a practical example, which I will not delve into too much details or give too much opinion, because the matter is the subject of proceedings currently in the Court of Appeal. And this is with regard to the appointment by the President of people to hold the office of Chief Administrative Secretary, commonly known as CASs, which was challenged in court, and the High Court by a majority struck down what the President had done in terms of the appointments. The matter is now in the Court of Appeal. But the point I wish to make here is that this is the President exercising a power in accordance with Article 132, Sabbatical 4A, which in my understanding gives the President powers to create those offices as long as this is done with the recommendation of the Public Service Commission. And I think in the matter in court, the two main issues that are contentious are the role of the Public Service Commission in those appointments, and the issue of public participation. Although in my reading of the majority judgment in the High Court, the court seemed to be saying, in any event, that the President does not have those constitutional powers. To the extent of that generality, I have my reservations on that interpretation, but I will leave it to us to reflect further after it has gone through the process, the appellate system. But that is an example of the exercise of that particular constitutional power given to the president. The president may also receive foreign diplomats and consular representatives. The president may confer honors in the name of the people and the republic. The president may, subject to Article 58, declare a state of emergency. Now, Article 58, you may recall, deals with the declaration of a state of emergency, which may only be done in certain circumstances, following a particular procedure which we looked at, and which procedure includes the approval of Parliament. But ultimately, it is the president, subject to Article 58, who is given the power to declare a state of emergency. The president may also, with the approval of Parliament, and again, we looked at that when we looked at the role of Parliament, with the approval of Parliament, the president may declare war. Article 5, the president shall ensure that the international obligations of the Republic are fulfilled through the actions of the relevant cabinet secretaries. You will recall from the chapter 1 of this constitution that the international obligations of the Republic are, by virtue of this constitution, part of the laws of Kenya. Article 133 deals with the power of mercy that the president has. The president has a power he may exercise, he or she may exercise in accordance with the advice of the advisory committee, which is established under this Article 133, to grant a free or conditional pardon to a person convicted of an offense, to postpone the carrying out of a punishment either for a specific or a specified or indefinite period, or to substitute a less severe form of punishment, or remit all or part of the punishment. Article 2 deals with the advisory committee, which shall consist of the Attorney General, the Cabinet Secretary responsible for correctional services, and at least 5 other members prescribed by an act of Parliament, none of whom may be a state officer or in public service. The exercise of presidential powers during temporary incumbency. Article 134. A person who holds the office of president or who is authorized in terms of this constitution to exercise the powers of the president, A, during the period commencing on the date of the first vote in a presidential election and ending when the newly elected president assumes office, or while the president is absent or incapacitated or at other times contemplated in Article 147.3. That is, those 2 scenarios are what the Constitution refers to as temporary incumbency. I think it's important for me to repeat those 2 situations. The constitutional limitation of powers of the president during those 2 situations. 1, during the period commencing on the date of the first vote in a presidential election and ending when the newly elected president assumes office. So, when the country goes into an election to elect the president, amongst others. On that date, this period of what the Constitution calls temporary incumbency begins, and that will end when a new president, the newly elected president, is sworn in or takes office. The second situation of temporary incumbency is while the president is absent or incapacitated or at other times contemplated in Article 147.3, which we shall look at shortly. During that period, the president may not exercise the powers of the president that are specified in the following clause. And those are: A, the nomination or appointment of the judges of the superior courts. B, the nomination or appointment of any other public officer whom this constitution or legislation requires the president to appoint. C, the nomination or appointment or dismissal of cabinet secretaries and other state or public officers. D, the nomination or appointment or dismissal of a high commissioner, ambassador, or diplomatic or consular representative. E, the power of mercy. And F, the authority to confer honors in the name of the people and the republic. So that list that I have just read out, during a period of a temporary incumbency as defined in the previous clause, which I read out, during that period, the president cannot exercise those powers. Article 135 is very important given our history in this country, and that is, it relates to the decisions of the president, and it provides that a decision of the president in the performance of any function of the president under this constitution shall be in writing and shall bear the seal and signature of the president. Under the former constitution, many things were done by the president by word of mouth, maybe even in writing, that did not necessarily bear the seal and signature of the president. But this Article 135 is important in that it requires that any decision of the president only has constitutional validity if it is, as I say, in writing, and it bears the seal and signature of the president. We move on to Article 136, which deals with the election of the president. And it provides the president shall be elected by registered voters in a national election conducted in accordance with this constitution and any act of parliament regulating presidential elections. And Sub-Article 2, an election of the president shall be held A, on the same day as a general election of members of parliament, being the second Tuesday in August in every 5th year, or B, in the circumstances that are contemplated in Article 146, which we shall look at presently. What are the qualifications and disqualifications for election as president? Article 137. A person qualifies for nomination as a presidential candidate if the person A, is a citizen by birth. Important. So if you are a Kenyan citizen by another process like naturalization or registration, but not by birth, then you do not qualify for nomination as a presidential candidate. B, if the person is qualified to stand for election as a member of parliament. C, that person is nominated by a political party or is an independent candidate. And D, the candidate for president is nominated by not fewer than 2,000 votes from each of a majority of the counties. So that as at today, we have 47 counties. So a majority of those counties would be 24 counties. So the presidential candidate must be nominated by not fewer than 2,000 voters from each of 24 counties. Sabbatical 2. A person is not qualified for nomination as a presidential candidate if the person, A, owes allegiance to a foreign state. I think that is fairly self-evident, but it's a constitutional provision. Or B, is a public officer or is acting in any state or other public office. Now, this latter clause 2 that I've just read out shall not apply to the president, the deputy president, or a member of a parliament. The procedure at presidential election. 138 sabbatical 1, if only one candidate for president is nominated, that candidate shall be declared elected. That is, again, self-evident. If 2 or more candidates for president are nominated, an election shall be held in each constituency. Here we're talking about a presidential election. In a presidential election, sabbatical 3, A, all persons registered as voters for the purposes of parliamentary elections are entitled to vote. B, the poll shall be taken by secret ballot on the day specified in Article 101, sabbatical 1, at the time, in the places, and in the manner prescribed under an Act of Parliament. And C, after counting the votes in the polling stations, the Independent Electoral and Boundaries Commission shall tally and verify the count and declare the result. That is at the polling station. Sabbatical 4. A candidate shall be declared elected as president if the candidate receives A, more than half of all the votes cast in the election. More than half. That means if you take all the votes that are cast, take half, then one more vote so that it becomes more than half. That is the threshold for election for president. And B, at least 25% of the votes cast in each of more than half of the counties. So however many votes a candidate may get, they must, again, as the counties stand at the moment, they must receive at least 25% of the votes that are cast in 24 counties. So even if you have, this is important to understand, even if you have a majority of votes cast, but they all come from maybe one region or 2 regions, and in any event, you do not have at least 25% of the votes cast in 24 counties, then you cannot be declared elected as president. Then, if no candidate is elected, a fresh election shall be held within 30 days after the previous election. And in that fresh election, the only candidates will be basically the top 2 candidates in the first election, the one who received the greatest number of votes and the one who received the second greatest number of votes. Now, if more than one candidate receives the greatest number of votes, then those 2 candidates or 3 candidates, whoever they are, that receive the greatest number of votes, those are the ones that shall be subjected to the second election. Then, of course, the candidate who receives the most votes in that election shall be declared president. Sabbatical 8. A presidential election shall be cancelled and a new election held if A. No person has been nominated as a candidate before the expiry of the period set for the delivery of nominations. B. A candidate for election as president or deputy president dies on or before the scheduled election date. Or C. A candidate who would have been entitled to be declared elected as president dies before being declared elected as president. So in any of those scenarios, then that election will be cancelled and a new election will be held. And in that case, that new election shall be held within 60 days after the date set for the previous presidential election. Now, sabbatical 10, within 7 days after the presidential election, the chairperson of the Independent Electoral and Boundaries Commission shall A. declare the results of the election and B. deliver a written notification of the results to the Chief Justice and the incumbent president. Now, this is an interesting provision to focus on because it gives that time limitation of 7 days within which the results must be declared. So the process from voting to declaration, all those processes, and Kenyans are familiar with them, the counting and at the polling center, the collating of the votes by the returning officer, the transmission by whatever process to the place specified by IEBC, the verification by IEBC, the tallying again at the national headquarters, and finally the announcement of the total tally and the declaration of the president. All that in terms of Article 10 must be done within 7 days. On reflection, the obvious potential difficulty that could arise in terms of the implementation of that sabbatical 10 of Article 138 is if for whatever reason, and this appeared potentially possible in the 2022 election and had begun even to cause anxiety, if potentially at the expiry of 7 days from the date of the election, the returning officer of the presidential election, that is the chair of IEBC, is not in a position to announce the final results and declare who is elected, what then happens? I will not venture to give an opinion on that, and I think it is something that should invite reflection and possibly the solution may be to have a constitutional provision that addresses what happens when or if that doesn't happen within that period of 7 days. But that's an important point to reflect on. Article 139 deals with a scenario where the president-elect dies before assuming office. 139.1, if a president-elect dies after being declared elected as president, but before assuming office, A, the deputy president-elect shall be sworn in as acting president on the date on which the president-elect would otherwise have been sworn in, and B, a fresh election to the office of president shall be held within 60 days after the death of the president-elect. I think that is fairly, once again, self-evident. Sabbatical 2, if the deputy president-elect dies before assuming office, the office of the deputy president shall be declared vacant on the assumption of office by the person declared elected as the president. Sabbatical 3, if both the persons declared elected as the president and the deputy president die before assuming office, A, the Speaker of the National Assembly shall act as president from the date on which the president-elect would otherwise have been sworn in, and B, a fresh presidential election shall be conducted within 60 days after the second death. Questions as to the validity of a presidential election. Article 140. 1. A person may file a petition in the Supreme Court to challenge the election of the president-elect within 7 days after the date of the declaration of the results of the presidential election. 2. Sabbatical 2. Within 14 days after the filing of a petition under Clause 1, the Supreme Court shall hear and determine the petition and its decision shall be final. 3. If the Supreme Court determines the election of the president-elect to be invalid, a fresh election shall be held within 60 days after the determination. Now, Article 140 is a very important article. And it has very, very strict timelines, which perhaps also bear reflection. 140 Sabbatical 1 requires a petition, presidential election petition, to be filed in the Supreme Court within 7 days from the date of the declaration of results. That's quite a stringent timeline and perhaps needs to be reflected on. The Supreme Court having 14 days after the filing of the petition to hear and determine the petition shall be is also a very stringent timeline. The provision in Article 140 Sabbatical 2 may perhaps also bear some reflection, but bearing in mind that as short as the timeline is for the court to hear and determine, as against that, there is the concern that after you've had an election, especially if it is a contested one, it is not in the interests of the nation to have to wait for too long for the matter to be determined. But I hold the view that the period of 14 days for the determination of such an important petition could bear review and reflection. That's my view. Now, 140 provides that the decision of the Supreme Court shall be final. In other words, that brings the issue of any contest about a presidential election to the end. So it's important that prior to that, because of that finality, prior to that, it's important that the parties involved, given timelines and the process in the Supreme Court, the parties involved should feel that they have received justice. And it's also equally important that once the Supreme Court has pronounced itself, and what I'm about to say is likely to be controversial in Kenya's recent experience. But I do venture to say that I think it's important that this provision of the Supreme Court being the final arbiter on a contested election, that should be well understood, and that should be well respected in the context of a process that is designed to deliver justice and bring an end to the contest. Sub-Article 3, if the Supreme Court determines the election of the president-elect to be invalid, a fresh election shall be held within 60 days after the determination. This is the process that the country underwent in 2017 when the Supreme Court of Kenya invalidated the 2017 the first election. The assumption of office of the president. 141, the swearing in of the president-elect shall be in public before the Chief Justice, or in the absence of the Chief Justice, the Deputy Chief Justice. I don't know, as we reflect, whether it would not be beneficial to also look at a scenario where neither the Chief Justice nor the Deputy Chief Justice are available for whatever reason, whether perhaps just a thought, the judges of the Supreme Court in the order of precedence, whether in that hopefully unlikely scenario, one of them could be the person before whom the swearing in is done. The president-elect shall be sworn in on the first Tuesday following the 14th day after the declaration of the result of the presidential election, if no petition has been filed, or B, the 7th day following the date on which the court renders a decision declaring the election to be valid, if any petition has been valid under Article 140. The president-elect assumes office by taking and subscribing to the oath or affirmation of allegiance and the oath or affirmation for the execution of the functions of office as prescribed in the third schedule. The Parliament shall by legislation provide for the procedure and ceremony for the swearing in of a president-elect. Yeah, that has been done. The term of office of the president, 142, the president shall hold office for a term beginning on the date on which the president was sworn in and ending when the person next elected president in accordance with Article 136 2A is sworn in. A person shall not hold office as president for more than 2 terms. Article 143 deals with protection from legal proceedings. Criminal proceedings shall not be instituted or continued in any court against the president or a person performing the functions of that office during their tenure of office. Secondly, Civil proceedings shall not be instituted in any court against the president or the person performing the functions of that office during their tenure of office in respect of anything done or not done in the exercise of their powers under this constitution. When you take those two, there is a difference between sabbatical 1 and sabbatical 2. My reading is that in criminal proceedings, there's a complete bar to bring criminal proceedings against a president or a person acting in the office of president. Number 2, in civil proceedings, the bar is only to the extent that those proceedings are in respect of anything done or not done in the exercise of their powers under this constitution. So my reading is such that if you have a private matter, say a commercial matter, a land matter, which has nothing to do with the exercise of the powers of the president, then there seems to me to be no constitutional bar to bringing those proceedings. But this is for reflection. Other people may have different ideas of how those two provisions are to be interpreted. Then sabbatical 4, the immunity of the president under this article shall not extend to a crime for which the president may be prosecuted under any treaty to which Kenya is party and which prohibits such immunity. That again is self-evident, and it would come into play, for example, if you were dealing with the International Criminal Court. Article 144, the removal of president on grounds of incapacity. A member of the National Assembly, supported by at least a quarter of all the members, may move a motion for the investigation of the president's physical or mental capacity to perform the functions of the office. If a motion under Clause 1 is supported by a majority of all the members of the National Assembly, A, the Speaker shall inform the Chief Justice of that resolution within 2 days, and B, the President shall continue to perform the functions of the office, pending the outcome of the proceedings required by this article. Within 7 days after receiving notice of the resolution from the Speaker, the Chief Justice shall appoint a tribunal consisting of A, 3 persons who are qualified to practice medicine under the laws of Kenya, nominated by the body which by law is responsible for regulating the professional practice of medicine. B, 1 advocate of the High Court, nominated by the body which by law is responsible for regulating the professional practice of advocates. And C, 1 person nominated by the President. If the Chief Justice is unable to appoint a tribunal under Clause 3, the Deputy Chief Justice shall appoint such a tribunal. Sabbatical 5, if the President is unable to nominate the person required to be nominated under Clause 3C, the person shall be nominated by A, a member of the family of the President, or B, if no such member is willing or able to make the nomination, by a close relative of the President. The tribunal shall inquire into the matter and within 14 days after the appointment, report to the Chief Justice and to the Speaker of the National Assembly. The Speaker shall cause the report of the tribunal to be tabled before the National Assembly within 7 days after receiving it. The report of the tribunal shall be final and not subject to appeal, and if the tribunal reports that the President is capable of performing the functions of the office, the Speaker of the National Assembly shall so announce in the National Assembly. If the tribunal reports that the President is incapable of performing the functions of the office, the National Assembly shall vote on whether to ratify the report. If a majority of all the members of the National Assembly vote in favor of ratifying the report, the President shall cease to hold office. Because here we are reflecting on the Constitution, I hold the view that possibly it would be helpful if the Constitution was a little clearer on a situation where a majority of members of the National Assembly do not vote in favor of ratifying the report. In other words, where a report says the President is incapable of performing the functions of President, but the National Assembly votes not to ratify that report. I think there is a need for clarity as what is the correct position in that scenario. Article 145 deals with the removal of President by impeachment. A member of the National Assembly, supported by at least a third of all the members, may move a motion for the impeachment of the President, A, on the ground of a gross violation of a provision of this Constitution or of any other law, B, where there are serious reasons for believing that the President has committed a crime under national or international law, or C, for gross misconduct. If a motion under Clause 1 is supported by at least 2/3 of all members of the National Assembly, A, the Speaker shall inform the Speaker of the Senate, that is, the Speaker of the National Assembly shall inform the Speaker of the Senate of that resolution within 2 days, and B, the President shall continue to perform the functions of the office pending the outcome of the proceedings required by this article. Within 7 days after receiving a notice of resolution from the Speaker of the National Assembly, A, the Speaker of the Senate shall convene a meeting of the Senate to hear charges against the President. And B, the Senate by resolution may appoint a special committee comprising 11 of its members to investigate the matter. A special committee appointed under Clause 3B shall A, investigate the matter, and B, report to the Senate within 10 days whether it finds the particulars of the allegations against the President to have been substantiated. The President shall have the right to appear and be represented before the special committee during its investigation. If the special committee reports that the particulars of any allegation against the President, A, have not been substantiated, further proceedings shall not be taken under this article in respect of that allegation. Or B, have been substantiated, the Senate shall, after according the President an opportunity to be heard, vote on the impeachment charges. If at least 2/3 of all the members of the Senate vote to uphold any impeachment charge, the President shall cease to hold office. 146. A vacancy in the office of the President. The office of the President shall become vacant if the holder of the office A, dies, B, resigns in writing addressed to the Speaker of the National Assembly, or otherwise ceases C, to hold office under Article 144 or 145 or under any other provision of this Constitution. Of course, 144 deals with removal on grounds of incapacity, and 145 deals with removal by impeachment. When a vacancy occurs in the office of the President, the Deputy President shall assume office as President for the remainder of the term of the President. Or B, if the office of Deputy President is vacant or the Deputy President is unable to assume the office of President, The Speaker of the National Assembly shall act as president, and an election to the office of president shall be held within 60 days after the vacancy arose in the office of the president. A person who assumes the office of president under clause 2, that's the one I just read, 2A, or following an election required by 2B, shall, unless otherwise removed from office under this constitution, hold office until a newly elected president is sworn in following the next regularly scheduled election under Article 136(2)(a). If the deputy president assumes office as president under clause 2A, or a person is elected to the office of president under clause 2B, the deputy president or the person elected shall be deemed, for the purposes of Article 142(2), A, to have served a full term as president if at the date on which the person assumed office more than 2.5 years remained before the date of the next regularly scheduled election under Article 136(2)(a), or B, not to have served a term of office as president in any other case. The functions of the deputy president. Deputy president, Article 147, shall be the principal assistant of the president and shall deputize for the president in the execution of the president's functions. 2, the deputy president shall perform the functions conferred by this constitution and any other functions of the president as the president may assign. 3, subject to Article 134, when the president is absent or is temporarily incapacitated and during any other period that the president decides, the deputy president shall act as the president. 4, the deputy president shall not hold any other state or public office. 148, the election and swearing in of the deputy president. Each candidate in a presidential election shall nominate a person who is qualified for nomination as president as a candidate for deputy president. And the Independent Electoral and Boundaries Commission shall declare the candidate nominated by the person who is elected as the president to be elected as deputy president. Article 6 of Article 148, the term of the office of the deputy president shall run from the date of the swearing in of the deputy president and shall end A, when the person next elected president at an election is sworn in, B, on the deputy president assuming the office of president, or C, on resignation, death, or removal from office of the deputy president. The deputy president may resign from office in writing address to the president, and the resignation shall take effect on the date and at the time specified in the notice, if any, or if a date is not specified, at noon on the day after the notice is delivered. A person shall not hold office as deputy president for more than 2 terms. So that provision is similar to the one of the president. The vacancy in the office of the deputy president. Within 14 days after a vacancy in the office of deputy president arises, the president shall nominate a person to fill the vacancy, and the National Assembly shall vote on the nomination within 60 days after receiving it. Now, Article 2 of 149 is important. If a person assumes office as deputy president under clause 1, then for the purposes of Article 148(8), the person shall be deemed A, to have served a full term as deputy president if at the date on which the person assumed office, more than 2.5 years remained before the date of the next regularly scheduled election under Article 136(2)(a), or B, not to have served a term of office as Deputy President in any other case. 150, the removal of the Deputy President. The Deputy President may be removed from office, A, on the ground of physical or mental incapacity to perform the functions of the office, B, on the impeachment, 1, on the ground of a gross violation of a provision of this Constitution or any other law, 2, where there are various reasons to believe that the Deputy, sorry, 2, where there are serious reasons to believe that the Deputy President has committed a crime under international law, or 3, for gross misconduct. The provisions of Articles 144 and 145, that is relating to removal of the President for incapacity or for or on impeachment, those provisions are relating to the removal of the President shall apply with the necessary modifications to the removal of the Deputy President. Article 151 deals with the remuneration and benefits for the President and the Deputy President. They shall be a charge on the consolidated fund. Those remuneration and benefits shall not be varied to their disadvantage while in office. And the retirement benefits, sub-article 3, shall also not be varied. The retirement benefits payable to former President and former Deputy President shall not be varied. And that includes the facilities and the privileges available to them shall not be varied to their disadvantage during their lifetime. Part 3 of the chapter on the executive, this deals with the cabinet. 152, Article 152, the cabinet consists of the President, the Deputy President, the Attorney General, and not fewer than 14 and not more than 22 cabinet secretaries. And the cabinet secretaries are nominated by the President for approval by Parliament, then the President appoints them. And they are not members of Parliament. The President, of course, by Sub-Article 5, has the power to reassign a cabinet secretary, to dismiss a cabinet secretary, and also, so the President can dismiss of his or her own motion, but also 5C shall dismiss a cabinet secretary if required to do so by a resolution adopted under clauses 6 to 10. Clauses 6 to 10 of this article deal with basically a process where Parliament, after initiation of a motion requiring the President to dismiss a cabinet secretary, which motion will be initiated if it is supported by 1/4 of all the members of the National Assembly. The grounds on which the motion would be based on would be A, on the ground of a gross violation of a provision of the Constitution or any other law. B, where there are serious reasons for believing that the Cabinet Secretary has committed a crime under national or international law. Or C, for gross misconduct. Now, if the motion is supported by at least 1/3 of the members of the National Assembly, then the National Assembly shall appoint a select committee, and the select committee shall report to the Assembly whether it finds the allegations against the Cabinet Secretary to be sustained, and the Cabinet Secretary has the right to appear and be represented before the Select Committee. And the Select Committee will either will report to the National Assembly, and if it reports that it finds the allegations unsubstantiated, that is the end of the matter. If it finds that the allegations are substantiated, the National Assembly then gives the Cabinet Secretary an opportunity to be heard and then votes whether to approve the resolution, requiring the Cabinet Secretary to be dismissed. And if that vote is carried, then if it is carried by a simple majority of the members of Parliament, then the Speaker shall promptly deliver the resolution to the President, and the President shall, and it's mandatory, dismiss the Cabinet Secretary. 153 deals with decisions, responsibility, and accountability of the Cabinet. Decisions of the Cabinet shall be in writing, and Cabinet Secretaries under 153(2) are accountable individually and collectively to the President for the exercise of their powers and the performance of their functions. Cabinet Secretaries are required have a responsibility when called upon to do so to appear before a committee of either the National Assembly or the Senate, and to do so to answer any question that concerns a matter for which that Cabinet Secretary is responsible. Sabbatical 4 requires that Cabinet Secretaries A shall act in accordance with the Constitution, and B shall provide Parliament with full and regular reports concerning matters under their control. Article 154 deals with the office of the Secretary to the Cabinet, which is established by Sabbatical 1. This person will be nominated by the President and appointed with the approval of National Assembly, and the President may dismiss the Secretary to the Cabinet. And the responsibilities of the Secretary to the Cabinet are to have charge of the Cabinet office, be responsible, subject to the direction of the Cabinet, for arranging the business and keeping minutes of the Cabinet, convey the decisions of the Cabinet to the appropriate persons or authorities, and any other functions as directed by the Cabinet. Article 155 establishes the office of Principal Secretary and provides that each state department shall be under the administration of a Principal Secretary. Principal Secretaries are nominated by the President and appointed. They are nominated by the President from persons recommended by the Public Service Commission, and they are appointed with the approval of the National Assembly. The President may reassign a Principal Secretary, and the Principal Secretary may, of course, resign in writing. Other offices that are established part of the executive, 156 establishes the office of the Attorney General, who is nominated by the President and appointed with the approval of Parliament. The qualifications for appointment as Attorney General are the same as for appointment to the office of Chief Justice. The Attorney General is the principal legal advisor to the government. B shall represent the national government in court or in any other legal proceedings to which the national government is a party, other than criminal proceedings. And C shall perform any other functions conferred on the office by an act of Parliament or by the President. The Attorney General, of course, is required to promote, protect, and uphold the rule of law and to defend the public interest. And the powers of the Attorney General, the legal powers of the Attorney General, may be exercised in person or by subordinate officers acting in accordance with general or specific instructions. The final office that is included on this chapter on the executive, interestingly, is the Office of Director of Public Prosecutions. I say interestingly because in reflecting on this, I ask myself, should the Director of Public Prosecutions properly be included or described as part of the executive? Why do I ask that? Because the Office of the Director of Public Prosecutions is essentially, and we will see this when we come to chapter 15 that deals with constitutional commissions and independent offices. This is intended to be an independent office. So should it then be included in the executive? But that's where it is, part 4 of chapter 9. There is established in Article 157, the Office of the Director of Public Prosecutions. The Director is nominated by the President and appointed by the President with the approval of the National Assembly. The qualifications for appointment of the DPP are the same as the appointment of a judge of the High Court. The DPP shall have power to direct the Inspector General of the National Police Service to investigate any information or allegation of criminal conduct, and the Inspector General shall comply with any such direction. The DPP shall hold office for a term of 8 years and shall not be eligible for reappointment. And Sub-Article 6 of 157, the DPP shall exercise state powers of prosecutions and may institute and undertake criminal proceedings against any person before any court other than a court-martial in respect of any offense alleged to have been committed. The DPP may take over and continue any criminal proceedings commenced in any court other than a court-martial that have been instituted or undertaken by another person or authority with the permission of the person or authority, and subject to clauses 7 and 8, the DPP may discontinue at any stage before judgment is delivered any criminal proceedings instituted by the DPP or taken over by the DPP. Now, 7 and 8. 7, if the discontinuance of any proceedings under clause 6C takes place after the close of the prosecution's case, the defendant shall be acquitted. And 8, the DPP may not discontinue a prosecution without the permission of the court. The powers of the DPP may be exercised in person or by subordinate officers acting in accordance with the general or special instructions. The DPP shall not require the consent of any person or authority for the commencement of criminal proceedings, and in the exercise of his or her powers or functions shall not be under the direction or control of any person or authority. That lends, in my view, support to my reflection and question of whether the DPP is properly included or described as part of the executive. Because generally speaking, the public officers in the executive take instructions or directions from the president or the deputy president, as the case may be. The DPP 157.10 is very clear, shall not be under any under the direction or control of any person or authority. The DPP is required in exercising their powers to have regard to the public interest, the interest of the administration of justice, and the need to prevent and avoid abuse of the legal process. 158, removal and resignation of the DPP. The DPP may be removed from office on the grounds only of A, inability to perform the functions of office arising from mental or physical incapacity, B, non-compliance with Chapter 6. You remember Chapter 6 deals with ethics and integrity, on the ground of bankruptcy, incompetence, or gross misconduct or behavior. Article 58 provides a process whereby any person may present, who desires the removal of the DPP from office, may present a petition to the Public Service Commission in writing, setting out the allegations. The PSC shall consider the petition if it is satisfied that it discloses the existence of a ground under clause 1 of this article 158. It shall send, in those circumstances, the petition to the president. Article 4 says, on receipt and examination of the petition, the president shall, within 14 days, suspend the director of public prosecutions from office pending action by the president in accordance with clause 5, and shall, acting in accordance with the advice of the Public Service Commission, appoint a tribunal which consists of 4 members from amongst persons who hold or have held office as a judge of a superior court or who are qualified to be appointed as such. B, 1 advocate of at least 15 years standing, nominated by the statutory body responsible for the professional regulation of advocates, and C, 2 other persons with experience in public affairs. The tribunal shall look into the matter, inquire into the matter expeditiously, and report on the facts and make recommendations to the president, who shall act in accordance with the recommendations of the tribunal. So, the president is obliged to act with whatever recommendations it is that the tribunal makes. Now, that is Chapter 9 of the Constitution that deals with the executive. It's an important chapter in the Constitution for the very simple reason that the executive in our constitutional architecture is pivotal in the governance of the Republic, pursuant to the executive authority that is delegated by the people of Kenya at the national level. It's a fairly detailed chapter. I have endeavored to, in my reflection, to point out 1 or 2 areas which I think would require further reflection for purposes of consistency within the architecture of the Constitution. But of paramount importance is to recognize and acknowledge that the powers that are exercised by the executive are given by the Constitution. Where necessary, they are limited by the Constitution. And of course, ultimately, the executive through the president, as we saw when we looked at the provisions that relate to removal of office of either the president or the deputy president, an extreme measure by any standards, but that is the ultimate accountability and the balancing within the different organs that form government. So I want to thank you for staying with me on this what has been a slightly longer session of reflection, and I look forward in the next session to look at another organ of the government, another organ that is part of the delicate architecture that is created by the Constitution. Thank you very much for staying with me, and I look forward to our next session.
Thank you.
Asante.